top of the docket. First case is Chandra Holland. Ms. Holland, good morning, ma'am. You're here for first appearance accused of one count of possession of drug paraphernalia. Ms. Holland, there is probable cause for this charge, ma'am. Actually, I don't know that there's probable cause. Before we get to that, Corporal, I asked the jail this morning for a urinalysis because Ms. Holland is on state probation. I never got the results of that, at least not before court started. Do we have those results?
Judge, did you get my text message I sent you before court?
I got your text message, but I don't know the results of the urinalysis. I don't know if she took it or she's just saying she will test positive.
She told me she would test positive, and she'll go take it if you want her to, but she's going to test positive.
Okay. Yeah, I do want her to because I want to know what substance she has in her system. She's on probation. And her saying she has X doesn't mean she may have X, Y, Z, and A. So I need to know exactly what's in her system, and she's on probation, so she's got to give you urinalysis. I am concerned about the search, though. I want to hear from the state and defense on the search because I've never seen this, and I have questions about whether or not that's appropriate. Ms. Bremer, what's the state's position on the search?
Your Honor, the affidavit does state that Mr. Tyndall left the passenger door open and the passenger in the back seat left his door open. The backpack that was in the passenger floorboard, the dog did alert to that. And then after the dog was put away, Mr. Tyndall made a statement to the officer about a clear glass pipe in the center console. And so the item was not found during the search. It was not found during the search with the canine. It was found as a result of the probable cause search after Mr. Tyndall made the statement that he did.
So the time sequence is people get out of the car, they leave them open. The officer somehow thinks it's okay to let the dog get in the car. To me, that's just like him putting his phone on a selfie stick and sticking it in the car window. It's entirely inappropriate unless you show me some law that says he can do that. And then after the dog gets in the car, the dog alerts inside the car. I don't think you can do that under Florida or federal law, under the Florida and U.S. Constitution, period. I don't think you can do that. I think it's inappropriate to let the dog get in the car without the owner's consent. Now, if you got some case law to correct me on that, I want to know it. But everything after that doesn't matter. Right. Because they use the dog's alert to justify everything else.
Well, it was my understanding, and I could be wrong, but my understanding from the report that the dog alerted to the backpack, which would have been available from an exterior search. I'm not sure if the dog was inside when he alerted to the backpack or not.
Mr. McDaniel, any input?
Your Honor, just to repeat what you said, I agree. I concur that that in this case, it's clearly a question, and I can't help to think that if the officers don't see that she's on probation and try to go out of their way to make something happen. I've seen it a lot the last couple of days, I guess, because they've been doing these roundups around everywhere, and it seems like I see a lot of searches being done with dogs and nothing's being found, and they all alert on something. I question these dogs. I shouldn't question the dogs. I should probably question the people who are handling the dogs. But that's another issue.
I don't buy that the officer could not control the dog well enough to keep him out of somebody's car. And if he can't control the dog well enough, he don't need the dog. So either he can't control him or he let him go in the car. And either way, I think it's inappropriate. I'm going to find no probable cause on the search, on the charge. Now, I'm going to hold her until tomorrow because she's on state probation, because if she fails a drug test, that's going to be a totally separate matter. And she's going to take a drug test, and if she refuses to take a drug test, then that's going to be a refusal to take a drug test, which is also going to possibly violate her probation. So I'm going to hold you till tomorrow, not because of the charge. Let me finish, Mr. McDaniel. I'm not going to hold you because of the charge. I'm going to hold you because of the allegations regarding the drug use, and you're on probation, so you can be compelled to take a drug test, or you can refuse to take a drug test, but refusing is a violation in and of itself. I'm going to see you tomorrow at first appearance. We'll have those urinalysis results, and we'll see exactly what's in your system, or we'll have a refusal to deal with. That gives law enforcement 24 hours, Ms. Bremer, to clarify. If the dog alerted before going in their car, I need to know that. The complaint, the way I read the complaint, the dog didn't alert until the dog got in the car. And I've never seen that officer allow a dog to get in somebody's car without their permission. And I don't think you can do that.
Yes,
that would shock me, because to me, it's just like the officer taking his phone, sticking it through the window and video and everything that he can't see from outside, and then pulling it out and watching it and basing probable cause on it. If he don't have authority to be in the car, neither does his dog.
Yes, Your Honor.
So, Mr. McDaniel, you were saying something?
Your Honor, I just want to say, Ms. Holland's she's going to take the drug test, and I've dealt with her many times in the past, and she's forthright with me every time I talk with her. I have no doubt she's going to fail the drug test, and it is what it is, and we're going to move on.
Ms. Holland, we'll see you tomorrow, but I'm not holding you on the charges. I'm holding you on a possible violation of probation, 24 hours, okay?
Okay.
All right, thank you. So after Ms. Holland.
Parker.
Brianna Parker. Ms. Parker, good morning. Ms. Parker, you're here for first appearance. You have 3 charges. You're accused as a fugitive from Texas. You're accused of the complaint says smuggling contraband. I think the statute is introduction of contraband into a correctional facility or a county detention facility and possession of marijuana less than 20 grams. Mr. McDaniel, does the state want to be heard? Defendants also want to be heard on the probable cause on the marijuana charges?
Your Honor, I don't think they have any kind of test that's been completed or any kind of evidence to convincingly say that, clear and convincingly that it is marijuana. So we'd ask that it lacks probable cause. She does have the hold out of Texas also, and we're hoping to go ahead and sign that waiver and let her go to Texas.
Ms. Bremer.
Your Honor, the state would request 24 hours to get an amended complaint to clarify on the issue of marijuana.
So Ms. Parker, Mr. McDaniel said clear and convincing, and that's the standard we use in some cases, but for first appearance purposes, it's probable cause. It's a lower standard. Ma'am, they've either got to have the right kind of test that says it's not hemp, or they've got to have someone saying, some person such as yourself or another occupant of the vehicle saying it's marijuana. They have neither of those. Ms. Bremer, I'm concerned because this is 2 within the last 3 days where we've had FHP misunderstand and misapply the law. So either I'm wrong about the law and there's been a change, which is certainly possible, or FHP officers not been educated about the marijuana hemp distinction that it's been over a year ago. So, but considering you've got a hold from Texas, what I'm gonna do is give them 24 hours to fix the problem, ma'am. I'm gonna hold you 24 hours to see if they can correct the problem. If they do establish probable cause in a written sworn complaint under oath, then I'll set your bond in that case. If they don't, we'll deal with the waiver of extradition tomorrow and see if you want to go to Texas. I'll release you on these charges if they don't fix the problem. Ms. Parker, I'm going to see you in the morning. Do you have any questions?
No questions, Your Honor.
All right, thank you. I'll see you tomorrow, ma'am. Calvin Pitts is next. Mr. Pitts, good morning. Mr. Pitts, you're here for first appearance. You've been accused of 1 count of kidnapping, 1 count of burglary with a battery. That both of those are first-degree felonies punishable by life. You also have a grand theft auto and a violation of state probation charge. Let me deal with the first 3 first, and then I'll deal with the violation of state probation. There is probable cause in those complaints. I actually was the judge that signed the warrants in those 3 cases back in 2020. I'm going to see if Mr. McDaniel or Ms. Bremer have anything else in those charges before I set the bond. Mr. McDaniel, anything on behalf of Mr. Pitts? I think you're muted still.
Mr. Pitts has been incarcerated the whole time, obviously, and, he's got a violation of state probation also. So I guess you can take that into consideration. And so.
Thank you. Ms. Bremer.
Your Honor, the state would just request that Mr. Pitts not be permitted to communicate or contact Ms. Cecilia Chancey or any other victim associated with the case.
Mr. Pitts, thank you both. Mr. Pitts, I'm going to set you a bond, but keep in mind you're going to have no bond in the VOP. So this, to a certain extent, doesn't matter unless you resolve the VOP. Based on the charges, they're very serious charges, and you've got a bad history. Your bond's going to be $100,000 each in these first-degree felonies punishable by life, $10,000 in the grand theft auto. So your bond is $220,000. But in addition to that, you have that no bond warrant that was signed by a different judge back in 17. Really? It's a 2017 no bond warrant. I'm going to arraign you on that and get you a lawyer appointed in that case and give you a court date if you would like to have a lawyer appointed in that case. So I'm talking about the violation of probation case now. Will you may appoint an attorney in that case?
Yes, sir.
I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel. He's going to give you a court date in that case.
Your Honor, we're going to plead not guilty. Asked to set this on the August 8th pretrial docket, and I've already advised you, Mr. Guy Green, to come visit him before that court date.
Anything from the state?
Nothing further, Your Honor.
The 220 does have a condition, no contact with the alleged victim, Mr. Pitts, and your court date will be the 8th of August, and Mr. Green will come see you at the jail before your court date. That court date will be on the VOSP. When's your arraignment on the felony docket? Because the information is already filed in this.
Same
So
day.
That
We just have.
same day. So you may be in court on all charges on the same day. You definitely will be there on the violation of state probation, okay?
Okay. Thank
Any
you.
questions, sir? All right,
No.
have a good day, sir. That brings us to Samantha Friedman, we already saw. That brings us to Dylan Young. Mr. Young, good morning. Mr. Young, you're here for first appearance. You're accused of 1, 2, 3, 4. You're accused of 5 charges. They are reckless driving, fleeing, and attempting to elude a law enforcement officer. That's the second-degree felony version of that. That's high speed or endangering other drivers or the public. No motorcycle endorsement, no motor vehicle registration, and tag attached, not assigned. I read the complaint. Mr. McDaniel, I don't know that there's probable cause on that tag attached. Anything you want to be heard on that?
No, Your Honor.
Ms. Bremer?
Your Honor, the state would just ask for a reasonable bond.
So, Mr. Young, on tag attached, not assigned, that statute actually is attaching the tag. They have to have evidence that you attach the tag. That means that you either have to admit it or somebody has to see you attach the tag. And there's none of that in the complaint. It just says that you were driving a vehicle with the wrong tag on it, a motorcycle. So there's no probable cause for that charge. You're not going to be held on that charge. On the other charges, I'm going to find there is probable cause, and I'm going to set you the following bond. The fleeing and eluding second-degree felony is the most concerning one. That's going to have a $10,000 bond. Reckless driving will be 5 based upon the driving pattern alleged. The other 2, motorcycle endorsement and motor vehicle registration, will be $2,500 each. When you add those together, Mr. Young, your total bond becomes $20,000 on the 4 that you've got a bond on. No probable cause on the tag attached. It's cash or surety, Mr. Young. That means you can go through a bondsman. You will get to use the phone in just a few minutes to try to post the bond. If you post it, you'll be out of there. If you're not able to post the bond, Mr. Young, then you'll be seen on an upcoming docket. Do you have any questions, sir? Have a good day, sir.
No, sir.
Good luck to you, man.
All right, sir. Thank you. Dakota Mack. Miss Mack, good morning. Miss Mack, you have a warrant out of Bay County, ma'am. It is a accessory after the fact charge that you've been accused of, Miss Mack. There's no bond on this. It looks to me like it's going to be a case where they address your bond when you get to Bay County, Miss Mack, but there's no bond now. I don't know when you'll get to Bay County. Usually it's within a couple of days. It could be today. Today is Wednesday, so it certainly could be this week. It is also possible, Miss Mack, it'll be next week before you get to Bay County. But when you get there, you'll go to another first appearance. Their first appearances are in the afternoon. That judge in Bay County will address your bond. It appears to me you're going to get one when you get down there, but not until then. Miss Mack, do you have any questions?
No, sir.
Miss Bremer, anything from the state?
Nothing, Your Honor.
All right, have a good day, ma'am. After Miss Mack, we have Charles Ford. Let me see Charles Ford and Benjamin Hamilton because their cases are similar for first appearance purposes, and I can see them both at the same time and maybe speed things up a little bit. Mr. Ford and Mr. Hamilton, I'm seeing you at the same time because both of you are charged of violation of state probation, and in both warrants, double check again, both warrants have no bond on it. So the circuit judge has issued no bond in your cases for violation of state probation. Mr. Ford, you also have a fugitive warrant from Houston County, Alabama. So you'll deal with that at some later date. For today's purposes, I want to arraign you on the state violation of state probation charges in Jackson County and get your lawyer appointed if you want one appointed. Mr. Ford, do you want an attorney appointed to represent you in the VOP here?
Yes, sir.
And Mr. Hamilton, same question.
Yes, sir.
I'm going to appoint the public defender's officer of the 14th Circuit to represent each of you. Listen to Mr. McDaniel. He's going to enter a plea for you and give you some more information.
Your Honor, we're going to plead not guilty. Asked to set this on the August 8th pretrial docket. I've already advised them, Mr. Guy Green, to come speak to them about their case before that hearing.
Thank you, Mr. McDaniel. Gentlemen, you have any questions about any of that?
No, sir.
All right, your attorney will be out there to see you before your court date, okay?
As long as they.
August 8th, yes, sir. He'll see you probably the week before that, which will be, means he'll see you, start say next week. That's not right. Janitha Jerome. Mr. Jerome, good morning. You're here for first appearance accused of one count of driving while license suspended or revoked habitual. Mr. Jerome, when I was preparing for court this morning, I got on the computer because I saw some recent arrests, and it looks like you have the same charge pending from within the last 2 weeks. And it also looks like you have a warrant out of Polk County for the exact same thing. So you have,
Okay.
you've got
No,
one
they
from
waived
Polk
my
County that's been
appearance.
issued in the last 2 weeks for failure to appear.
They waived
Unless
my
you-
appearance and I was incarcerated during the time. But
Okay.
like yesterday, I wasn't driving. They just was trying to take somebody to jail. Like
Yeah,
I
according to
wasn't driving.
according to the complaint, you were driving. There were 2 vehicles and you were driving one of them according to the complaint. You have 8 prior driving license suspended. You have a felony driving license suspended pending in another state. So what I want to do is this. Let me first see if Mr. McDaniel or Ms. Bremer have any additional information. Mr. McDaniel,
I don't have the warrant.
Nothing else, Your Honor.
we'll get the jail to check on the warrant. Ms. Bremer, anything from the state?
Your Honor, I believe you covered everything.
So Ms. Jerome, because of the number of charges you have and because you've got one pending and now you're driving again 2 weeks later, allegedly, your bond's going to be $25,000 in this case. There's no bond for 10 days for Santa Rosa case. Ms. Bremer, she has a pending felony driving while license suspended in Santa Rosa County is 23-982 CF. She's been on bond less than 2 weeks and she's on a $5,000 bond. So please notify Santa Rosa County of that and see if they want to seek to revoke her bond. According to my computer system, she also has a warrant out of Polk County, different county, in 22-515 CT for the same thing, except it's a misdemeanor version of driving while license suspended. It does have a bond on it of $3,000. So Corporal, she says the one out of Polk County, is not a warrant. So I need y'all to check on that, Corporal. Do a warrant check on her, please, and make sure, and then advise her if she's got the warrant out of Polk County. So Ms. Bremer, I guess there's really nothing for y'all to do. And Polk, you actually still need to notify them because she was on bond before that. So this could violate their bond too. Mr. Jerome, I'm going to see you in 10 days. If Polk and Santa Rosa, if neither one of those wants you, then I'm going to release those holds and you'll be free to post the bond here. But if either one of them wants you, we're going to hold you for them and honor that request. But we're going to see. So I know you won't be driving for the next 10 days. And after that, we'll see what happens. Mr. Jerome, I'm going to see you in 10 days. Do you have any questions?
Yeah, with this case that I have with your county, how would that, because that bond is high, so would I be able to like do pleas or something in 10 days or a lower bond?
No, I'm not going to set you a lower bond because you've got the same charge pending in 3 counties and it appears you won't quit driving. So a $5,000 bond didn't do the trick. So that's why I'm setting it at $25,000. That's a high bond for driving license suspended, but you don't see many people that have 2 felony driving licenses suspended in 2 different counties within 2 weeks. So the bonds, that's the bond that you're being set. As far as the 10 days or something, I'm going to hold you 10 days with no bond, and that's going to give everybody time to look in these other counties. If they want to revoke your bond out of Santa Rosa County, which is certainly possible, maybe even likely when they find out what you're accused of, if they do that, you very well may have no bond out of Santa Rosa. That'll be a judge's decision over there. That's not my decision. So I'll know more in about 10 days, okay? Have a good day, ma'am. So she's got 25 here, 10-day hold for 2 other counties. And that's Polk and Santa Rosa. Thomas Riggs. Mr. Riggs, good morning. Mr. Riggs, you're here for first appearance accused of 1 count of criminal mischief while at the jail. Mr. Riggs, there is probable cause for that charge. I'm going to set your bond at $10,000 cash or surety, Mr. Riggs. It's a felony charge you're accused of. That bond is in addition to any other jump bonds that may or may not have been set. So I think you may have had no bond on something. I'm really not sure, but you've got a $10,000 bond on this charge. Mr. Riggs, any questions?
Talk to you soon. All right.
Have a good day. Mr. McDaniel, as far as first appearances goes, is that everybody's first appearance list?
Yes, Your Honor.